May I be permitted?
We'll start from that side. From one side, yes. Yes,
For inclusion in the list.
yes,
By the inclusion connection.
yes, yes.
Actually, this is matter relating to the 2011. Record is lying with the principal bench. Last Friday, I mentioned before the division bench, and division bench asked me to.
We'll have to call for the records. The matter is appearing in the list.
No.
So you hand over a slip. We'll try to call for the records. Or should we go? Should we go before this principal bench when it is?
Lordship,
The matter relates to review of somebody's order. Some judges.
Lordship, it's life imprisonment, and one
So
can have to be.
we have determination to take up those matters.
Lordship, record lying there. Record has to be completed.
Please hand over slip. Yes. Yes.
Matter ultimately issue which we are district inadvertently matter has been filed for the principal bench. Can it
Kuch Bihar, do you cover Kuch Bihar? Yes, hand over. Yes.
My lordship, there are 4 criminal applications pending.
Applications means in connection with appeal.
Yes, connection with the.
Hello. Yes.
To the item number 201 of minor list matter. The matter pertains to the granting ad interim order of injunction. So if your lordship kindly take it this matter at today at 2 PM or tomorrow at the top, my lord.
We cannot give any preference to these matters, civil matters. We can fix a date for taking up civil matters first, but we cannot right now because there are so many bail matters, Mr. Bhattacharya. Cannot do that.
Matter.
It's appearing in the list. We'll fix a date. No, we can fix a date for taking up, say, Friday, we can take up first civil matters, then proceed with the other matters.
Yes, my lords.
So we'll keep it on Friday then.
In the trial court, the next date fixed on 25th, Thursday.
Give a notice. We cannot give any preference to these matters because the bail matters are too many. Auditro, Friday, first day, civil matters, no matter. Please hand over the slip, we'll take it up.
Lordship, may I permit to mention, Lordship, today item number 267, this is a second appeal, Lordship. There is a direction to file, release the matter appropriate bench, Lordship. There is a delay.
Yes, we'll take up civil matters on Friday.
Lordship, I pray for release the matter because the Lordship, the Lanet Court, Trial Court, Lordship, executing proceedings is started, Lordship.
So how will you help?
Lordship, I pray for release the matter, Lordship.
Why?
Lordship, so that I can mention the matter before the single bench, Lordship.
Oh, this is a second appeal hearing,
there is a,
not order 41.
No, Lordship, there is a second appeal, Lordship. There is a
second appeal has been admitted.
No, Lordship.
Section 5.
Yes, Lordship.
Yes, hand over a slip. Itake single party, almost single party. Yes, leave granted.
Lordship, I'm here to mention one matter. It's a matter of contempt by your lordship order.
Single or division?
Single, your lordship.
Mention before the single. When I sit singly, mention the matter.
By your lordship, your lordship.
When I sit singly today, mention the matter.
Okay.
Call on the list. Yes.
Lord, in item 1, I appear for the petition.
What is the period of custody?
Lord, 814 days.
What is your mitigating circumstance?
My Lord, there is gross violation of 52A. My Lord, the samples that were seized at the spot were, my Lord, ultimately sent to the FSL.
Not sent to FSL.
Were sent to the FSL. The samples that were seized from the spot were, my Lord, sent to the FSL. So, my Lord, the Supreme Court in its recent judgments have said that this constitutes the primary evidence in any NDPS case. So, my Lord, in the meantime, they had also approached the magistrate for an inventory. But, my Lord, ultimately, the samples that were seized from the spot, which happens to be A1, B1, and C1, were sent to the FSL, my Lord, and, my Lord, from there, the reports were called for. Now, my Lord, the contraband is a little bit above intermediate quantity.
According to you, what should have been done?
My Lord, the samples that were, my Lord, collected at the inventory before the magistrate should have been sent.
So that has not been done here.
No, my Lord.
What do you say?
My Lord, 1 day accommodation.
No, first matter, no.
One CD, my Lord.
This gross violation, my Lord.
1 day.
This person will be in jail for another day. Why? We are passing it over whenever you are ready, come back. Passing it over whenever you are ready, just inform him and come back, we'll take up the matter. Yes, next matter. The password rule? Yes.
My lord,
Yes, please.
I am for the petition. চলে আসুন। The allegation of may I lordship?
Yes,
The allegation is seizure of 41 bottle of penicillin, lordship.
right.
Codeine mixture from my shop. And the shop is a kabari shop, lordship. It has no specific description. Kabari shop, my lord understands. So position is actually constructive, not the conscious position, lordship. Cannot be said from any corner of a kabari shop, a contraband was seized. It cannot be said to be a conscious position because the shop is
rejected earlier.
Lordship,
Why it was rejected earlier,
earlier.
22nd, 4th April.
Lordship, we are not on that point. The point that was not we have come up before your lordship with a point that was not considered earlier.
You did not press before benches.
Lordship, we didn't adjourn the matter, lordship. It was the time.
It was not pressed before Justice Das's bench and Justice Mantha's bench. Anyway, what do you say?
Lordship, let me submit.
Oh,
The
yes.
point is on 52A, lordship. Violation of section 52A, lordship. The date of seizure, kindly come, lordship. The annexure attached to my petition.
Yes,
The date of seizure is 7/8/2023, lordship.
right.
That is appearing from the seizure list.
Annexures we'll see later. If they oppose, then we'll see the annexures. Just give us the date. Yes.
The date of seizure is 7/8/2023. Date of inventory is 18/9/2023.
Yes. Anything else?
And it was sent to FSL on 22/9/2023. Now I'm coming to my point. This case was initiated in the year of in the year 2023, lordship.
Right.
Now there is a rule, there is a new rule of NDPS. NDPS new search and seizure, there's a new rule in 2020. It must be in the record because it was hard in part earlier.
আর কিছু আছে কাগজ?
আছে কিছু দেখুন তো জাজমেন্ট আর
এগুলো?
কিছু আছে
These.
কপিটা
Yes, rules are there. After one copy only. Anyway, we'll share. Yes, as per this.
As per this, lordship, kindly come to rule 8, lordship.
Yes.
Application to magistrate. What is the procedure, lordship? Procedure is that no sampling should be done at the time of seizure, lordship. But immediately after the seizure, the inventory is to be done, and thereafter immediately the learned magistrate is to be approached for collection of sample and certification of the inventory. This is the law, lordship. Now, the application to magistrate, it has to be made as soon as, at the earliest, the expression, the bottom line, last line, first word, the earliest, lordship. Now, rule is very specific now. Next, coming to lordship, rule 13 of the same rule. Rule 13,
Yes.
dispatch of sample
Without any delay, chemicalized.
without any delay, lordship.
Right.
Without any delay. And Mohanlal has confirmed no sooner. The expression no sooner has been used in the Mohanlal judgment, lordship. When there is a delay, lordship, there is always a chance of tampering with the samples, lordship. There is in total a delay of 53 days in sending the sample to the FSL lab. Total delay is 53 days. I am in custody for more than 11 months, lordship.
Anything
Lordship,
else? Yes.
Now I'm placing placing reliance upon a judgment of Honorable Supreme Court. May I? My lord is aware of the Mohanlal judgment. I'm relying upon para 16 and 17 of the judgment, where the Honorable Supreme Court has been pleased to observe the necessity and the expression no sooner has been used. The expression no sooner has been used. Immediately, how important it is, lordship. The expression
Yes.
no sooner has been used. Now I'm relying upon another judgment of the Supreme Court, lordship. It is in 2020, it is a 2023 judgment, lordship. The judgment in the case of Samarjit Singh. Relying upon Mohanlal, lordship, the court observed that when there is a delay, there is a suspicion. And the most important judgment I have, Lordship, although it doesn't have a binding effect on this division bench, Lordship, but the observation is unique. That is why I am pressing this judgment before your Lordship, because this judgment pertains to a bail application. Lordship,
Yes.
the observation of the Honorable Delhi High Court, Lordship.
Right.
From paragraph number 24 to 35, the categorical analysis, paragraph 25 is very important, Lordship. Yeah. Very significant. In the present case, the sample was kept in the custody of the prosecuting agency for more than 1.5 months, thus raising doubt about the with regards to tampering of the same. When it was kept in the custody of the investigating agency, there is a natural presumption that it was tampered. There was a long delay, Lordship. There is a gross violation of the rules. Rules are mandatory. And when there is a violation of the mandatory provision, the entire case goes. If the case goes, Lordship,
Yes.
then what is the purpose of keeping me behind the custody? Under the statute, the purpose of detention is preventive, not punitive.
What are you otherwise? What do you do normally?
I'm a shopkeeper, merely shopkeeper. I run
You said kabaddi shop. Yes. Very
I
well.
have a
Let us hear them. Yes.
May I hand over the case diary?
Yes.
So kindly have a look on the Seizure list that is on page 16, madam.
Case number
Page 16.
16,
Page
60.
16, 16, madam, the Seizure list.
Yes.
Lord, from the Seizure list, my lord, it reflects that, my lord, the entire contraband article has been seized from the possession of this particular person.
True, but how do you do?
Get over this. Judgment certificate. 1.5 months delay is sending the sample.
My lord, pertaining to the direction,
Actually, everything in
my
NDPS.
lord, pertaining to the directions, my lord, that has been imposed in Mohanlal. My lord, the issue is kept pending in the my lord, the Honorable Apex Court. My lord, what is this? My lord, may I hand over, my lord, I have one copy of judgment. My lord, the Honorable Apex Court has, my lord, directed all the states and as well as the union territories, my lord, to file a, my lord, action taken report with regard to the whether the directions that has been mandated in Mohanlal judgment has been complied or not.
That it reinforces Mohanlal.
No, my lord. My lord, kindly have a look on, my lord, the observation of the Honorable Apex Court. The matter will be returnable on, my lord, 29th of August.
Follow-up action. What is
Follow-up
the
action,
action on Mohanlal. That means
Yes, my lord.
the report is reiterating Mohanlal.
That-
What is the follow-up action done by the state? That
It
has
is
been asked.
nearly 10
My lord,
years, my lord. Mohanlal is 2016 judgment.
And my lord, the matter will be, my lord, returnable on 29th August. So whether, my lord, the direction with regard to, my lord, Mohanlal judgment and how much complied, my lord.
Here the investigation is complete. Calcutta is-
Yes,
Yes,
yes.
What is the use of keeping in custody? NDPS sector.
My lord, he is the sole accused. my lord.
But then that is a great lacuna. I mean,
I'm a local resident, Lordship. I'm a small
My lord, he is the
shopkeeper.
sole accused.
Give me a local surety. I will meet the IO every day. Every day, Lordship. Every day. And there are coordinate bench.
there are counsel for the petitioner.
Counsel for the petitioner points out that the sample was seized on August 7, 2023, whereas it was sent for inventory as long thereafter as on September 18, 2023, full stop. The sample was sent to FSL for SFL report, FSL on September 22, 2023. Full stop. It is submitted that in view of the gross delay of more than 1.5 months in sending the sample even for inventory, the principle laid down in Union of India versus Mohanlal and another, reported at 2016 3 SCC 379, has been violated. For sub next para, that apart, it is argued that the petitioner runs a within double inverted kabaddi double inverted close shop, dealing with scrap and tidbit matters, and the position was merely constructive and could not have been conscious. For sub next para, learned counsel also cites in support of his contentions the judgment of Simaranjit, Simarnjit Singh versus State of Punjab, where the Supreme Court reiterated Mohanlal's ratio. For sub next para, that apart, learned counsel also cites a coordinate bench judgment of the Punjab High Court the Delhi High Court in the matter of Kashif, Kashif versus Narcotics Control Bureau. Full stop, next para. Learned counsel appearing for the respondent state places reliance on the Seizure list, which indicates that possession was found from the shop of the petitioner and the petitioner's involvement cannot be ruled out. Full stop. Next para. Learned counsel also contends that the Supreme Court has issued directions on the states to ascertain whether follow-up action has been taken by the states in compliance of the directions in Mohanlal. Full stop, next para. The petitioner is in custody for 11 months. Full stop. The investigation is now complete and charge sheet has been filed. Full stop, next para. We find from the circumstances of the case that the sample was sent even for inventory more than 1.5 months, more than about 1.5 months from the date of seizure, comma, which casts palpable doubt on the veracity of the samples, comma, following the principle laid down in Mohanlal's case and even otherwise by the Supreme Court and the coordinated bench of the Delhi High Court. Full stop, next para. The judgment cited by the respondent merely reiterates the proposition of Mohanlal, comma, since the Supreme Court sought to ensure that the directives laid down in Mohanlal and another has been complied with by the states. Full stop, next para. Thus, comma, we find sufficient prima facie lacunae in the case of the prosecution to grant benefit of doubt within the provisions of section 37 within bracket 2 of the NDPS Act 1985 to the petitioner. Full stop, next para. We cannot also lose sight of the fact that the petitioner runs a shop dealing with tidbits, and as such, it cannot be altogether ruled out that the petitioner might not have been in conscious possession of the contraband. Full stop, next para. In such view of the matter, comma, CRM NDPS 240 of 2024 is allowed, comma, thereby granting bail to the petitioner on condition of furnishing bond of rupees 10,000 with 2 sureties of like amount each, one of whom must be local, to the satisfaction of the special court NDPS at Siliguri. Further, comma, the petitioner shall not make comma, directly or indirectly, comma, any inducement, threat or promise to any person acquainted with the facts of the case so as to dissuade such person from disclosing such facts to any police officer or the court and or tamper with evidence in any manner whatsoever. Full stop. That apart, comma, the petitioner shall not indulge in any offense for which the petitioner has been accused in the present case and shall not leave the territorial jurisdiction of the trial court throughout the period of trial. Full stop. The petitioner shall, comma, during the entire period of trial, comma, be attend the hearing on each and every date. Stop. Thank you.
2000 volume 9 SSC, page 549. Go through the judgment. 2000 volume 9 SSC, page 549.
Satisfaction.
Art Lusami judgment.
Obliged, Lordship.
Thank you.
Yes. Right.
Yes.
My lord, I am for the petition.
Yes, Mr. Guha, what is the matter?
My lord, in this case, my lord, I'm in custody about 257 days. My lord, charge sheet submitted on 24th of April 2024. And my lord, allegation is that my lord, this person, my lord, is carrying my lord, 22 bottles of aspartate plus my lord, cough syrup. And my lord, 10 bottle is my lord, commercial quantity, he's carrying 20. And my lord, 30 sticks of my lord, even cell spas plus capsule.
How do you get over 37?
My lord, but there is 52, my lord, the delay of my lord. Sending the.
What is it?
There are two conditions in section 37 of the NDPS Act. We have to satisfy. Right, Nagi?
There is a delay, of sampling,
What is the delay?
Is it delay the ground in the section
there
37?
was no delay. As per the FIR, 8 November 2023, the incident was occurred, and on 18/11/2023, the inventory was done as per the charge sheet.
10 days is reasonable.
In the meantime, inventory was done, so.
Refuse করছি।
This is the first application.
We do not find from the circumstances of the case that sufficient grounds have been made out to get over the bar enumerated in section 37 of the NDPS Act 1985. FUSAP accordingly, CRM NDPS 243 of 2024 is rejected, thereby refusing bail to the petitioner at this stage. Yes, what is the matter?
I'm applying for this tribunal.
Right.
Your lordship, kindly, there is the seizure list as also the FIR, my lord. No narcotic substance was recovered from the present petitioner. Narcotic substance was recovered from one co-accused, namely Lolita Roy. Only cash amount was recovered from the present petitioner. Your lordship, kindly see the seizure list as also the FIR, my lord. This is seizure list, my lord.
What was your involvement according to them?
Well, according to them, I am mere only standing nearby.
What is your relation to Lolita?
No relationship. I do not know her. Anyway, my lord.
You do not know her from after the seizure or before this?
My lord, there is no relationship. No narcotic substance was recovered from me, my lord. For this reason, section 37 did not lie, my lord. And in this regard, I want to rely on one judgment of coordinate means there are two co-accused standing, and from another co-accused recovery was made. There is section 37 did not lie against the present petitioner, my lord. FIR also, my lord, clearly stated that, my lord, no narcotic substance was recovered from me, my lord.
Yes, what do you say?
This is the seizure list, my lord, and column 3, from whom seat, from the exclusive possession of number 1 Lolita Roy and number 2 Bal Bahadur Tamang, that is the petition. No, my lord. Kindly see the description, my lord. Description of seizure list, my lord. Kindly see, my lord. Description. My lord, description says, my lord, in the FIR. Column number 3, lord. My lord. Next, my lord, description of article 6. One.
Both are named.
No,
Exclusive version person.
Kindly see, my lord. Kindly, 1 minute. My lord. One yellow color cotton, so and so, recovered exclusive possession of the Lolita. And number 2, my lord, one transparent plastic packet containing 26 grams of brown sugar recovered from the from Lolita.
First one is Lolita.
First one, second description is also Lolita, my lord.
Yes.
Third is Indian currency, my lord, from the Bal Bahadur Tamang, exclusive possession. If your lordship kindly see the FIR also, my lord. FIR, my lord, written complaint, my lord. Kindly see the second page of the written complaint, my lord. Description, my lord, clearly stated from recovery. My lord, last paragraph of the written complaint also, my lord.
Indian currency was recovered.
Yes, my lord, Indian currency recovered from the present petition. This is the second topic, my lord. No recovery, my lord.
Contraband substance এর body থেকে পাইনি।
I, my lord, one similar situation, one judgment I referred to.
Investigation still in progress, your lordship.
I will cooperate with you.
CFHL report yet to be collected, and my lord, arrest was made on 13th of May 2024, and inventory was prayer for inventory.
Yes, but how is the presumption under 37 raised against this person? He was not in possession.
Kindly
Yes, your seizure list says that Lolita was in possession of both the contrabands, transparent pouch and those other things. Bottle.
He was accompanied with the.
He was there with the
Lolita.
cash,
As per the seizure list, that's true, my lord.
not from his person.
My lord, investigation still in progress, your lordship. Totally matter of trial, your lordship. Kindly see the column number 3. From whom seized?
Column number 3 is qualified by column number 5.
Yes. That's
Column number 5, 3 is a misdescription actually,
yes.
because 3 has to go. It was not found from his exclusive possession as per your 5 description of seizure.
That's true.
So there is a contradiction which is patent.
Well, investigation still in progress, your lordship.
Investigation is that is not a panacea.
Maybe
এর পয়সা
Other
থেকে
than
পাইনি
files,
37 আসছে
lordship.
37 আসছে কারেন্সি না কারেন্সি তো স্যাম্পল টেস্টিং এ পাঠানো Yes.
My submission is a matter of trial.
Yes, yes.
And
so we'll-
investigation is still in progress, Your Lordship.
Learned counsel for the petitioner points out that as per column number 5 of the Caesar list, comma, the contraband article was not found from the possession of the petitioner. Full stop. The petitioner's involvement was restricted to recovery of Indian currency notes, whereas the substance was found from the other co-accused person, Lolita. Full stop. Next para. Learned counsel for the prosecution, learned counsel for the respondents points out that as per column number 3, comma, the articles were seized both from the possession of Lolita Roy and the present petitioner. Full stop. That apart, comma, it is contended that investigation is still progressing and the arguments raised by the petitioner are a matter of trial. Full stop. Next para. We find from the description of the seized articles in column 5 of the Caesar list that the same does not tally with column 3. Full stop. Whereas column 5 specifically indicates that the contraband article was found from the exclusive possession of the co-accused Lolita Roy, comma, the petitioner was only found to be in possession of Indian currency notes. Full stop. Hence, comma, there is a patent contradiction between columns 3 and 5, comma, the former describing the exclusive possession also found from the petitioner, whereas the description of Caesar contradicts it. Full stop. Next para. Hence, comma, we do not find anything to impose the strict rigor of section 37 of the NDPS Act insofar as the present petitioner is concerned, comma, who stands on a different footing as the co-accused Lolita. Full stop. Next para. Accordingly, CRM NDPS 244 of 2024 is allowed, granting bail to the petitioner on condition of furnishing bond of rupees 10,000 with 2 sureties of like amount each to the satisfaction of which court?
Special court NDPS at Siliguri, madam.
Special court NDPS Siliguri. Full stop. Next para. The petitioner shall meet with the investigating officer once every fortnight and shall not leave the territorial jurisdiction of the police station. You will reside within the police station jurisdiction.
Outside.
Within the territorial jurisdiction of the trial court throughout the period of investigation as well as trial, and shall make himself available as and when required for cooperating with the investigation by the investigating officer. Full stop. Moreover, comma, the petitioner shall not make any directly or indirectly inducement, threat, or promise. Thank you.
Madam, deep down. Wait.
My Lord, I am for the petition.
Yes, please.
The petitioner is in custody for near about 11 months, my lord. My lord, there is a delay in certification of the samples, my lord. Seizure was made on 6th of September 2023.
Sample sent when?
Seizure was made on,
Sample sent when?
sample was sent on 7th of November 2023, after 2 months.
Why didn't you take these points before the two coordinates?
My lord, before Justice Chakraborty, he has passed it over to the next bench. And in the next bench, my lord, my lord, before Justice Bakshi, the matter was placed to be withdrawn, but my lord knows.
So, what is the stage of the trial?
My lord, trial has not begun, my lord, till date.
Charge sheet submitted,
Submitted, my lord.
Charge sheet had been submitted on January 24, 2024.
No, Your Lordship, 29th of February 2024. 29th of February 2024.
Report 13 May 2024, when the bail was rejected.
13 May, last rejected, my lord, 13th of May 2024.
In this regard, my lord, I would like to place
13/5. 13/5, 2024.
Union of India versus Mohanlal judgment, my lord.
There is a judgment of apex court that it is a matter of trial. It will not be decided at the time of hearing of the bail application. Only the impact with section 37. You have to overcome that section, nothing more.
My lord, there is order of Justice Bhattacharya in this regard, my lord.
regarding delay, my lord. May I place?
The Mohanlal's case overrides by order. Mohanlal's case is there.
No, my lord has stated no loss in while granting bail, my lord. May I place, my lord?
Two months delay le Mohanlal পড়ে
Second
যাচ্ছে।
paragraph, my lord. Since there is no explanation for the delay.
Yes, what do you say? True, these were not considered. Charge sheet has been submitted after, before that order, but that was not considered then. If it is thrashed in the course of trial, let it be thrashed. Why should he remain in custody? Because sample 2 months delay is sufficient. You are in the custody for 11 months.
Near about 11.
Learned counsel for the petitioner contends that the delay between the seizure of the sample and sending the same was more than 2 months, comma, the respective dates being September 6, 2023 and November 7, 2023. Full stop, next para. Learned counsel relies on the principle laid down in Mohanlal's case by the Supreme Court in that regard. Full stop, next para. It is also pointed out that while the previous division bench rejected a similar prayer for bail on May 13, 2024, comma, this aspect was not gone into detail, but it was observed that the issue requires to be thrashed in the course of trial. Who's up next para? Learned counsel for the respondent submits that charge sheet has been filed on February 29, 2024 and opposes the prayer. Who's up next para? We find that although the matter may definitely be thrashed out at trial, comma, the ratio laid down in Mohanlal's case casts considerable doubt as to the very premise of applicability of section 37 of the NDPS Act in the present case, comma, since there may be sufficient doubt as to the veracity of the sample which was retained by the investigating authorities for over 2 months. Full stop. In such mitigating circumstances, comma, we are inclined to grant bail. Accordingly, CRM NDPS 246 of 2024 is allowed, granting bail to the petitioner on condition that the petitioner furnishes a bond of rupees 10,000 with 2 sureties of like amount each, one of whom must be local, to the satisfaction of the Special Court NDPS Act, Siliguri. Full stop. The petitioner shall make himself available, shall attend on each and every date of trial, and shall not leave the territorial jurisdiction of the trial court throughout the period of trial, and shall not directly or indirectly make any inducement, threat or promise or is sentenced.
Deeply obliged.
Thank you. Next.
Lordship, I am for the petition.
I am appealing for this.
Yes.
Lordship, I am renewing my bail application. Twice it was not pressed and it was rejected on 8/3/2024, 4 months ago, on the ground of delay of 72 hours, 52A, which was rightly rejected and not considered. I'm not on that, Lordship. If I am permitted to make my submission, this is an interesting case, Lordship. I am making my submission. Kindly see page 14 of my petition, the FIR. Lordship, the third paragraph, which starts with on 25/4/2023.
Yes.
Lordship, says about such and such, we reach at such and such in front of Gopi Mohan Stadium and called 2 independent witnesses, namely Khairul Hussain, mobile number such and such, and Sujan Pradhan, mobile number such and such, and briefed them regarding our purpose of Naka checking duty. Both of them voluntarily agreed to accompany us as witness in procedure. So 2 independent witnesses were there. One is Khairul Hussain and Sujan Pradhan. Now kindly, Lordship, sees page 21, the arrest memo. In column 10, one Monindra Nath Bormon's name is there. Now, who is this Monindra Nath Bormon? Kindly sees, Lordship, page 24, the charge sheet, where the name of the witnesses are there. The name of this Monindra Nath Bormon is nowhere found in the charge sheet, in the name of the witnesses. This is my one point. So,
it is a, my humble submission, this name of Monindranath Burman is a fictitious name given by the prosecution, and the arrest was not made at the PO at the relevant point of time, as because where two independent witnesses were present who were during the search and seizure and arrest, why their signature was not obtained in the arrest memo. At the
What is the stage of the trial?
Lordship, I'm coming to the next. The stage of trial, Lordship, only charge sheet has been filed, nothing. And another point is, Lordship, it was a scooter, the contraband scooter belonging to another person. Now, Lordship, it is a private vehicle. Lordship knows under section 42 of NDPS Act, 42(1) and 42(2) has to be complied with. Lordship, in this regard, in page 26, I have given a citation of a coordinate bench, Lordship. Kindly see para 12, and relevant portion is, Lordship, para 19, where 42(1) and 2 has not been complied with in this case, Lordship, which is a mandatory direction of the apex court.
Have you gone through the judgment of authored by the Chief Justice of India, reported in 2021, 10 SCC, page 100?
What is the name of the judgment, Lordship?
Mohammad Nawaz Khan.
Yes, Lordship.
What is said in judgment?
Nawaz Khan, Lordship, if any connection is there.
Section 42.
42.
It's a matter of trial.
Lordship, then 41B, the first part. And if Lordship sees the what happens to the 41B, during trial also, 41B. Lordship, I'm relying to a judgment of our reported in 2015 SCC. Kindly, Lordship, have
2015.
15. No, Lordship, it is a trial judgment. What happens if 41B is not complied with? Lordship, kindly sees page 12 onwards. Page 12 onwards. And the relevant portion is the para 8. And the last portion that is the arrest of appellants on the place of occurrence was not proved due to non-compliance of the provision of clause 1 of subsection B of
appeal against the conviction.
Yes, Lordship. So in
What
the
is the
trial also,
trial?
Lordship, I'm not on that point. If it is a matter of trial and in the during trial, this point was considered and conviction was given, and in the appeal, what happened? Appellate court says no, non-compliance of 41B. The accused has been acquitted. So if that is the intention of the authority and legislature, that non-compliance of 41B is
a chance be given to the prosecution to prove his case.
But my lord,
it is not the
my lord, if it is not complied,
CRPC is there, your lordship. 311 CRPC is there, your lordship.
Yes. So it is there
At the time of trial.
at the time of trial.
overcome করবেন মনিন্দর witness list নেই independent witness
Memo of arrest.
memo of arrest independent witness যে মনিন্দ্রনাথ বর্মন তার নাম ওদের witness লিস্টে নেই, কিভাবে প্রুভ করবে প্রসিকিউশন? এই witness লিস্টে মনিন্দ্রর নাম নেই।
Original is there. We can call the witness.
yes, Lordship, but yes,
এলে
this is not a quashing case, but what I say is that if this raises a doubt in the mind of the court and dilutes section 37, why not, Lordship, I get a chance to bail even, Lordship. I'll face the trial. Whether what happens, the
Supreme Court
witness comes.
repeatedly said that the only the criteria is that section 37. Repeatedly said.
Yes,
that
Lordship,
because they are-
37. Now, whether this non-compliance raises a doubt in the mind of the court.
What is non-compliant?
28th of June,
Subsection
28th of June 2024.
41B.
41B.
And Lordship, if it's 311, the accused, the witness can be called. What is his address?
yes,
Lordship?
what do you say?
Nothing is saying. His address.
Last date was fixed for consideration of charge, that is on 28th of June 2024.
Charge sheet you have filed.
Charge sheet.
How do you overcome this? Monindranath Bormon's name is not there in the witness list.
That is
He was the
not-
only independent
that is not
witness.
the charge sheet, your lordship. I have seen your lordship. 311 is there at the time of trial. His father's
You
name
can,
prosecution
but then there
There in
is,
the criminal procedure code to
Yes.
call any of the witnesses.
but there is sufficient doubt then cast on the Seizure.
Lordship, another is that if the prosecution wants to call the witness, his name, address,
Doubt.
whatever, nothing is there in the charge sheet. How can he call? Who is Mohindra Mormon?
Is there any bar?
How can the court ascertain, lordship?
Yes, you have been sufficiently tested. Yes. Learned counsel for the petitioner points out that there was palpable discrepancy in the process of arrest, inasmuch as one Monindranath Bormon finds place and signs as the only independent witness, as an independent witness in the memo of arrest, whereas his name does not find place in the witness list. Push up. Next para, it is further contended that the recovery was allegedly made from a private scooter, which cannot be counted as public place. Push up. Learned counsel places reliance on a coordinate bench judgment of this court in CRM NDPS 546 of 2023, where the learned single judge was considering Butta Singh versus State of Haryana, reported at 2021 SCC Online SC 324, for the proposition that a private vehicle cannot be treated to be a public conveyance or come within the expression within double inverted public place as explained in section 43 of the NDPS Act. Push up. Next para, it is contended that such discrepancies create sufficient doubt on the applicability of section 37 on the in case of the petitioner. Push up. Next para, learned counsel appearing for the prosecution submits that charge sheet has been filed and the matter now sought to be raised by the petitioner can very well be thrashed out at trial. Push up. It is submitted that there is no bar for calling a further witness during trial. Push up. Next para, undoubtedly, learned counsel for the prosecution is justified in submitting so. Full stop. However, we find from the memo of arrest that Monindranath Bormon, as rightly pointed out by the petitioner, was the independent witness who signed therein, whereas his name does not find place anywhere else till date as a witness. Full stop. Next para, hence, some doubt is cast insofar as whether a sufficient case has been made out against the petitioner within the confines of the NDPS Act to justify further confinement of the petitioner throughout the period of trial. Full stop. Next para, in such view of the matter, there is sufficient doubt that the petitioner has not committed the offence at the prima facie stage, and that there is little chance of the petitioner committing such offence is let on bail. Full stop. Moreover, certain stringent conditions are contemplated to be put in order to obviate such act by the petitioner. Full stop. Accordingly, CRM NDPS 248 of 2024 is allowed, granting bail to the petitioner. Same conditions, যেগুলো আগে দিয়েছি.
Deeply obliged.
Thank you. To the satisfaction of which court?
Session Judge Jalpaiguri.
Session judge.
Under NDPS Act, additional session judge.
Special court NDPS for third court.
Lordship, first court, now it's first court.
First court.
আপনি ছিলেন? Oh, আচ্ছা. So satisfaction additional session judge first court within bracket
That time it was third court.
under NDPS Act at Jalpaiguri. ওই জন্য
My lord, item 1 that was passed over, my lord, the prosecution has this case diary.
yes. The want.
My lord, as I had submitted, my prayer for bail, my lord, stands on 3 principal grounds. Firstly, my lord, the custody is 814 days. Second, my lord, there is gross violation of 52A, as my lord, the samples that were seized from the spot were ultimately sent to the FSL. Thirdly, my lord, there is prolonged delay in trial, as because, my lord, in the month of October 22, the charge sheet was submitted, my lord, till date, none of the witnesses has been examined, my lord.
The samples which has been sent are from the spot without
Yes.
inventarization.
I'll show it to your lordship. My
My
lord,
lord, this is the
certificate of the inventory certificate, my lord. And page 115 is the FSL report.
Milord, for that, Milords will kindly come to the FIR first. From where,
So let him complete his case, we'll come
Yes,
to this. Yes.
Milord, the
Anything
FIR
else?
is at page 10. Inventory certificate.
Yes.
Now, Milords will find the seized contraband is starts from the first paragraph itself. So, Milord, 8 odd kilograms from 3 packets were Milord seized. And Milord, representative samples were drawn out, exhibit A1 and A2 from each packet. So, Milord, these were the samples seized from this spot. Now, Milord, after that, an inventory was conducted before the magistrate. Now, Milord, this is the inventory certificate.
I've already placed it.
No, that has been placed before us.
Yes. Now, Milord, kindly seize the inventory certificate.
Yes.
The third paragraph is, Milord, important.
Yes.
Thereafter, the said ganja was weighed on the weighing machine. The said packet containing contraband items were then kept aside. Thereafter, representative samples of the seized contraband were drawn out from the said packet and placed inside one packet of ganja, which is 100 grams, which was sealed and labeled in my presence by IO Pranay Gurung, SIF Police, Fashidawa Police Station. So, Milord, before the magistrate, all the representative samples were mixed out, and Milord, one packet was, Milord, drawn out before the magistrate, which was 100 grams. Now, Milord will kindly come to the Milord FSL report. It is at page 21 of my application.
My lord, on page 150.
Now, Milords will find
Same document. Yes.
Milords will find the samples. The parcels consisted of 3 covers marked A1, B1, and C1.
Yes.
So, Milord, these were the samples that were seized at this spot, as I had shown you, lordships, from the FIR. In the meantime, inventory was in fact conducted, but Milord, ultimately the samples that were sent were the samples that were seized from this spot. Hence, Milord, gross violation of 52. Milord, 52A specifically states that the samples that are drawn before the magistrate have to be sent to the FSL because they constitute.
Isn't there any possibility that the samples retained their numberings after
No, Milord,
inventory?
because as I had shown to your lordship that before the magistrate, the 3 samples were mixed up, and Milord, 1 packet was ultimately drawn out, which was 100 grams. But Milord, in this you will find that A1, B1, and C1 were ultimately sent to the FSL.
Achha.
Is it a ground for bail
Yes, Milord.
for the judgment?
Yes. Milord, my ground for bail, Milord, are 2 more.
No.
Milord.
Judgment of apex court.
Yes, Milord. Simanjit Singh says that 52A, if there is violation, then that vitiates the prosecution's case. So, Milord, if the prosecution's case is vitiated, that is a ground for bail, that is a settled law. Now, Milord, my second ground is there is prolonged incarceration of the Milord petitioner. He happens to be in custody for 814 days.
Trial has been commenced.
No,
My
Milord.
lord,
12 witnesses are to
When
be
the charge
examined.
sheet was submitted.
my lord, there is a present, sir.
When the charge was framed.
Charge framed in the month of November 22.
22.
November
How many witnesses are
22.
there?
12
How many-
witnesses.
12 witnesses.
12. None have been examined until today. And Milord, in Ravi Prakash versus Orissa, the Supreme Court has said, Milord, that prolonged.
Yes, what do you say?
This is the present.
Charge sheet filed in November 22, trial has not started.
My lord, this is the present, sir.
814 days is sufficient ground. What is this?
Present status.
Ask. 12 witnesses, he said. 12 witnesses.
Yes, my lord.
Why the trial has not been commenced?
That are to certain.
The petitioner seeks to cast doubt on the process of sampling insofar as it is pointed out from the case diary that whereas the samples collected from the spot were marked as exhibits A1 and A2 as well as exhibits B1 and B2, they were subsequently mixed up and a single 100-gram sample was placed for inventorization. Full stop. However, the samples sent for FSL report by chemical analysis were the original samples recovered from the spot marked as exhibits A1 and A2, which itself is sufficient to vitiate the presumption under section 37 of the NDPS Act. For some next para, that apart, The charge sheet has been filed long back and charges were framed in the month of November 2022. And there are 12 witnesses named by the prosecution, whereas the trial is yet to commence. Full stop, it is submitted by learned counsel that the prolonged incarceration of 814 days is sufficient ground for grant of bail to the petitioner. Full stop, next para, learned counsel for the prosecution opposes the prayer for bail. Full stop, next para, upon a careful consideration of the materials, comma, we are of the opinion that palpable doubt has been cast in the process of sampling, comma, since the contrabands recovered from the spot were those which were sent for medical chemical analysis as opposed to the inventorized article. Puts of that apart, comma, it is well settled that prolonged incarceration, comma, in the present case 814 days, comma, is itself sufficient ground, comma, since the charges were framed as long back as in the month of November 2022 and the petitioner even thereafter is languishing in custody without the commencement of the trial. Full stop, accordingly, we are inclined to grant bail to the petitioner. Full stop, CRM NDPS 110 of 2024 is allowed, comma, granting bail to the petitioner on condition that the petitioner furnishes bond of rupees 10,000 with two sureties of like amount each to the satisfaction of the, yes,
Additional sessions judge, second court at Shiliguri.
এটা লিখে নিন। শিলিগুড়ি ফুল স্টপ নেক্সট প্যারা ওই ইউজুয়াল আগের গুলো থেকে করে নিও ওদের গুলো যেগুলো হয়েছে সেম তাই এটা সাবধান কেস ডায়েরি ছিঁড়ে না যায়।
We'll wait for not today, my lord.
Not today. Next.
Maybe day after tomorrow.
Day after tomorrow?
Yes, your lordship.
Very not today, not tomorrow. Up to 8?
8 only.
Oh, this is 8. Right.
Grateful, your lordship.
Thank. 9.
9, I'm for the petition.
Yes, please. What is your ground?
My lord, I'm in the custody since 573 days. Charge sheet was submitted on 25th of June 2023. And after charge sheet, it's already 373 days already passed. But till today, copy is not served, charge is not framed, and there is no progress in the trial. I am relying to judgment of Ravi Prakash versus State of Odisha, and another one is State versus Shiva Chakraborty. Judgment.
Ravi Prakash was NDPS?
Yes, my lord.
Another judgment is there.
Another judgment is there. My lord.
2023 SCC online. Rajuram versus State of Bihar.
Lord, I will.
Subsequent
Write it down, my lord. Say.
subsequent judgment.
Yes.
It will help you.
I'll also write it down.
My lord, another judgment is passed by the Honorable Division Bench of
No,
Justice.
his lordship has already given another judgment. So we are, yes, subject to hearing.
The next date is fixed on 30 of July for production and appearance. 30 of July. Only fact.
You're opposing also.
Right.
Learned counsel for the petitioner points out that the petitioner is already in custody for 573 days. First up, whereas the charge sheet was filed on June 25, 2023, comma, even after lapse of 373 days thereafter, comma, charges have not been framed, comma, nor have copies been given to the petitioner. First up, next panel, learned counsel relies on the judgment of Ravi Prakash versus the State of Odisha, where the Supreme Court, comma, while relying on the fundamental right guaranteed under Article 21 of the Constitution, observed that the prolonged incarceration, comma, generally militates against such most precious fundamental right, and in such a situation, comma, the conditional liberty must override the statutory embargo created under section 37 within bracket 1 within bracket small b within bracket small ii of the NDPS Act. Full stop next parallel and counsel for the prosecution opposes the prayer for bail and submits that the next date fixed is on July 30, 2024 for production. Full stop next para. In line with the ratio laid down in Ravi Prakash Supra, we are of the opinion that the long period of incarceration of the petitioner, who is languishing in custody over 373 days even after the filing of the charge sheet without charges being framed and copies being served on him, is sufficient justification for overriding the rigors of section 37 of the NDPS Act. Full stop accordingly, CRM NDPS 251 of 2024 is allowed, granting bail to the petitioner. Similar conditions to the satisfaction of the additional sessions judge, first court within bracket NDPS Act, bracket close at Jalpaiguri. Is that the court?
Yes. Great.
Right.
My lord, I am for the petitioner. Petitioner was arrested 24th February 2014. My lord, 2024.
praying for 1 day accommodation.
My lord,
One day accommodation. He'll be in jail another day.
CD not available. Kindly.
Not today. Come back tomorrow. Yes.
I'm for the petitioner, my lord.
Yes, Mr. Govind.
My lord. My lord, actually, I am praying for bail on the grounds of non-compliance of 52A. Now, before praying for bail under George Lordship's attention, I'm handing over a copy of the charge sheet and the relevant portion I've already highlighted.
There is a delay, my lord.
52 days delay, my lord.
Sending the sample.
Sending the sample. I have already handed over the charge sheet, my lord. And the relevant portion I have highlighted. Now, my lord, kindly see, the arrest was and the seizure was effected on 21st November 2023. And the matter was sent to the FSL on 11th January 2024.
In view of the prolonged delay in sending the sample for chemical analysis, being of about 52 days, palpable doubt is cast on the involvement of the petitioner in the concerned offence and as to whether the petitioner shall commit such offence if enlarged on bail. Full stop. Thus, the rigors of section 37 of the NDPS Act cannot operate as a bar in the present case insofar as the grant of bail is concerned. Full stop. Accordingly, CRM NDPS 254 of 2024 is allowed. Same conditions, same court.
Our objection.
Oh, I'm sorry. Learned court additional session.
but you said that there is a delay.
I've admitted that because this, as per the CD,
No,
I have an objection.
No,
That will be at the time.
যেখানটা accordingly বলে allowed বলছি যেখানে তার আগে একটা লাইনে
Fair enough.
learned counsel
I
for
should not
the
say.
learned counsel for the prosecution
Submitted the CD, my lord.
opposes the prayer for bail.
How can I over this,
Then submit
delay,
such
my
a
lord?
question. Don't say in such a way.
Yes, call on it.
I'm for the petitioner, my lord. Now, my lord, kindly see the page now 15, memo of arrest. Signed by the one RPF personnel in the NGP platform. The only ground of my,
Where do you collect these matters?
my lord, fortunately or unfortunately, that comes to my hand. Page 15, my lord. And there I have relied upon one judgment passed by your lordship. RPF personnel signed as a witness. Though
It was night at 10, near about 10:30 PM at night. No civic, no public was present.
NGP
That
relates
was the judgment, that was the judgment of the apex court. If the witnesses were not found at the time of midnight, then anyone can be cited as witness. The judgment is there.
Maybe, my lord,
Cannot say that it is the.
my lord, one indulgence I am seeking. This is an NGP railway station. At 10:30, none was there. It is hard to believe. It is hard to believe. In all over, it was crowded till 6 p.m. to next day morning 6 a.m.
Learned counsel for the petitioner points out that in the memo of arrest, comma, the sole signatory in column 10 is a personnel of the Railways Protection Force within bracket RPF, comma, which itself vitiates the process of arrest. First up, it is contended by learned counsel for the prosecution for the respondent that it is well settled that in the event no witness is available at the relevant juncture, comma, anyone can act as a witness. Push up, the arrest was effected around 10:30 p.m.
My lord,
10:30 p.m. In the NJP, in the New Jalpaiguri railway station, and as such, there was dearth of any other witnesses. Push up, next para. We find it rather a difficult pill to swallow, that at 10:30 p.m, comma, in a busy railway station such as NJP, comma, there was no other available witness than a member of the RPF team to sign as the sole independent signatory. First up, although learned counsel for the respondent seriously opposes the prayer for bail, comma, we are of the opinion that the process of arrest being prima facie vitiated, the presumption under section 37 has to be relaxed. Full stop. Accordingly, CRM such and such allowed.
Coordinate bench of this court has passed a judgment. 2023 SSC
Granting
online
bail.
Calcutta 4188.
Satisfaction to
Instead happening in Tenjing Noke bus stand.
Special Judge NDPS
my lord,
Act,
one
Siliguri.
indulgence I am seeking. That judgment was partially overruled by the next coordinate bench. So far my knowledge goes.
That is for knowledge.
And that time that was rejected and subsequently that was allowed. The same person was there. If I am not wrong, subject to your lordship's correction.
Yes.
My lord, I am for the petitioner. Petitioner was 432 days is custody. My lord, there are firstly violation section 52A. My lord, 4 days delay.
4
My lord,
4 days delay in sending the sample.
My lord, inventory. My lord, 4 days.
Not accepted. Anything else?
My lord, later on, the charge sheet was submitted 12 November 2023.
Yes.
My lord, FSL report till to date not submitted. No supplementary charge sheet was submitted.
Now, regarding the non-submission of FSL report with the charge sheet, the Supreme Court, it's a very recent decision, my lord. Already the matter is pending before the
judgment is
larger
there.
bench.
My lord, I want to submit
So it's on the last
One
paragraph, my lord,
judgment-
same thing. And regarding the delay, there is only 3 days, 3 days delay. my lord, there is no-
without FSL report, the trial is vitiated.
The Supreme Court is pending.
At the time of hearing of the bail application,
It
has been done, it should be taken into account or not?
Mosumi Bhattacharya and the honorable,
Is it a matter of acquittal, appeal?
no, my lord, it is the bail matters. My
He
lord,
was already, my lord, he
the
the resident,
FSL
he is a resident of Bhutan. There is
My
no
lord,
question, my
FSL
lord.
report-
So,
FSL report till.
Here it has been
today
referred to a larger bench.
yes. And it has been categorically stated that it has been tagged with the case of 2023.
If it is referred to a larger bench, it cannot be
No, my lord, the
conclusive.
explanation is there.
My lord,
That is, sir, in that case, it cannot be said as an incomplete charge.
No, here it was held whether automatically entitles him for default bail or not. Default bail, no question of default. We are not agreeable to.
And this is a
My
delay
lord,
of 3 days
kindly
only.
see
No,
the,
that delay we are not bothered about. But why haven't you? I mean, the FSL report, the charge sheet has been filed.
Charge sheet has been filed with
has
a
been
prayer.
filed on,
Let him
It has
complete.
been filed with a prayer that once we get the FSL report, we'll be filing the supplementary charge sheet. And it's a case of 14th of May 2020.
There is a prayer in the charge sheet,
Yes,
perhaps, first
yes,
charge sheet.
yes.
but till to date, no charge sheet was filed. No supplementary charge sheet was filed.
No, we are
There
not
is a
in.
prayer in the first charge sheet. When the report of the
Yes,
FSL will
yes.
be
Right.
That has to be there, yes.
My
Uh,
lord, first charge sheet was filed, 12
Yes, we are not inclined to. Learned counsel for the petition.
2022.
Learned counsel for the petitioner submits. Learned counsel for the petitioner submits that there was a delay of about 4 days in sending the sample for chemical analysis. Full stop. Moreover, comma, it is argued that the charge sheet was filed without the FSL report. Full stop. Next panel, learned counsel appearing for the respondent opposes the prayer for bail and submits that the minuscule delay in sending the sample cannot be a justification for grant of bail, overriding the provisions of Section 37 of the NDPS Act 1985. Full stop. That apart, comma, in the charge sheet itself, comma, there is an indication that FSL report shall be filed as and when obtained. Full stop. Next para. We do not find that sufficient ground has been made out to override the mandatory provisions, otherwise mandatory provisions of Section 37 of the NDPS Act to grant bail to the petitioner. Accordingly, CRM NDPS 256 of 2024 is dismissed. At this stage, একটা দিয়ে দিও, to grant bail at this stage. Thank you. Next. হ্যাঁ, আপনারা নামাতে পারবেন না, এত জমে গেছেন, ওই জন্য মোটামুটি একটা এদিক ওদিক স্ক্রিন জাস্টিস হয়ে যায়। Yes, call on the matter. 14.
This is an application for bail.
Yes.
Recall of bail. The present case relates to the section under section 20B C of NDPS Act. Your Lordship, the petitioner were arrested on 18 July of 2023 and produced before the special court under the NDPS Act
আপনার দুবার
of Jalpaiguri. And the complainant by way of the
twice rejected
My lord. It was
by the same bench.
On 12th of May.
12th of
12th of March.
12th of March.
Huge quantity, 107 kgs of.
Ganja.
Why should it be granted to you, bail? Twice rejected.
The investigation agency had submitted a charge sheet on 10th January of 2024, but without FSL report.
Previous case.
That cannot be itself a ground.
Until today, investigation agency miserably failed to submit the FSL report, resulting which without trial, the petitioner are behind the bar more than 368 days. My lord.
Yes, expedite the FSL report, please.
My lord.
And when the application failed, the
My lord,
application was
we'll be
turned
filing
down.
it very soon.
Yes. Learned counsel for the petitioner contends that the charge sheet was filed in the present case without FSL report, and due to no fault of the petitioner, comma, the petitioner is behind the bar for how many days?
368 days.
368 days. Full stop. Next para. Learned counsel for the respondent points out that on 2 recent occasions, comma, bail was refused to the petitioner. That apart, comma, it is submitted that as and when the FSL report is obtained, comma, the same shall be filed. Full stop. Upon considering the materials, comma, we find that no mitigating circumstance or subsequent event has occurred after March 12, 2024, comma, when the bail of the petitioner was last rejected, comma, to grant similar relief to the petitioner. Full stop. Insofar as the delay in filing the FSL report, comma, there is no specific bar in law to file additional charge sheet after the obtaining of the FSL report. Full stop. As such, comma, we are not inclined to grant bail to the petitioner in view of the provisions of Section 37 of the NDPS Act 1985. Hence, CRM NDPS 258 of 2024 is dismissed. At this stage, no reason to grant at this stage. We'll come back in 5 minutes and take up the rest. There's a resolution probably. Whatever you people say, I mean.
Small quantities of narcotic substances allegedly seized from the possession of these 3 persons here.
Which 3 persons?
Persons were apprehended by the police and detained in custody. That is this.
In item 15?
No, sir, 17, 15, item number 15.
Pardon?
Lordships, small quantity, the available offense, why this I am detained in custody?
These matters, why don't you ensure? Because you knew CD not available, you should ensure that these are available. First few matters, at least the CD should be available. We are making it not today, then what can be done? Regarding the resolution, whatever decision you take, till then we'll take up the matters.
Let us talk with secretary.
Yes, yes. In the meantime, let us take up matters. Yes. Not true.
I am appealing for the petition.
Yes. What is the matter?
Below commercial quantity, brown sugar 35 grams. I mean,
Custody for?
1 month.
Yes, who is appearing for the respondent?
From joint possession, 35 grams of brown sugar was seized.
Who is for the state?
Come back tomorrow, Mr. Bhatt. ওটার রেজলিউশন নিয়ে কমিউনিকেট করে না কমিউনিকেট করা উচিত।
I am for the petitioner, my lord.
Yes, Mr.
I am in custody, my lord, 5 years, 6 months. Only one witness have been examined.
Stage of trial, 1 witness.
One witness.
How many total?
Out of, my lord, 8 witnesses. 5 years, 6 months, and, my lord, 26 days.
When the charge was framed.
Charge was framed in the.
Today is the date fixed, my lord, in the lower.
ওই সুপ্রিম কোর্টের জাজমেন্টে যেটা সূর্যকান্তের we are granting it. The petitioner is already in custody for 5 years, 6 months and 26 days. Post of next para, as held by the Supreme Court in several judgments, comma, the overriding special right granted under Article 21 of the Constitution of India prevails over Section 37 of the NDPS Act, particularly in cases where the the accused is in custody for a prolonged period, comma, languishing as an under trial. Full stop. Keeping in view such principles, comma, although objected to by the state, comma, we are inclined to grant bail to the petitioner. Full stop. Moreover, comma, no objective purpose would be served in keeping the petitioner in custody further during trial. Accordingly, CRM NDPS 264 of 2024 is allowed, granting bail to the petitioner. Yes?
This is happened by CLHC, Calcutta High Court Legal Service Authority.
First time bill application.
This is the application I have been appointed by the CLHC.
Unfortunate. Oh, same order, special court, NDPS, Darjeeling.
But the amount may be reduced because he has been appointed by Legal
Right,
Service
Right.
Authority.
Furnishing bond of rupees 1,000.
Grateful.
The other side. I think 17.
If both of you are here, we can take up the matter. Let us take up 17. 17 I call. Below commercial quantity.
Yes, mother. Yes, no good. But my lord,
Yes, otherwise what do you say?
The investigation is going on, very recent case, 22nd of June. Today is 1 month. So
What is his involvement as per your?
from his position, his position it was found, my lord. But it is true, my lord, below commercial quantity.
Oh, driver. So, learned counsel for the petitioner points out that the recovered articles are below commercial quantity, and as such, the rigors of section 37 of the NDPS Act are not applicable. Full stop. Learned counsel for the state opposes the prayer for bail and submits that investigation is still ongoing. Full stop. Next para. However, keeping in view the fact that the contraband articles recovered were below commercial quantity, and that the petitioner is a driver by profession, and his career may be hampered if at this early juncture, he is unnecessarily incarcerated, we are inclined to grant bail to the petitioner subject to the following conditions. Full stop. Accordingly, CRM NDPS the 263 of 2024 is allowed granting bail usual amount of 5,000 to the satisfaction of
Session Judge Alipurduar.
learned sessions judge at Alipurduar.
May I seek one indulgence? Your lordship has observed unnecessary incarceration, Lord. So kindly unnecessary word.
Give us a synonym.
Lord, incarceration.
Unnecessary যেটা দিয়েছে একটু bold করে we'll find some synonym. Less harsh or something like that. Yes.
I'm grateful.
এটা bold করে দিও একটুখানি. You're the president, we can understand. What is your advice?
The members of bar adopt the decision of Calcutta High Court bar. Not to what today.
So lies then. Very well. So we not sit singly also then.
কি